I still have probably spent more time on data breaches and data security than I have on privacy proper. It's probably like 55-45. It's not far off, but it does mean that I tend to have a more technical approach to a lot of what I do. I will ask my clients questions. How exactly does this API work? Is it spitting out a JSON, some other kind of data format? I'll delve into that nitty-gritty a little bit more than I think a lot of privacy lawyers will. By no means do I ever neglect important privacy concepts that are more sort of human-oriented when we talk about notice, when we talk about transparency. But I do really insist on understanding the technical details.
Welcome to Privacy in Practice, the podcast where we bring you the latest insights, practical solutions, and real-world stories from the world of data protection and privacy. I'm Kelly Dupree.
And I'm Donnie Strachen. Privacy in Practice is brought to you by VeriSafe, your trusted partner in privacy and data protection. In this podcast, we dig into the challenges and opportunities in privacy compliance, from navigating complex regulations to building a sustainable privacy program that works for your business, not against it.
So let's jump in and get practical with privacy.
Today, we're very excited to welcome Peter Jaffe to the podcast. Peter is a seasoned expert in privacy and technology law with extensive experience navigating the complex legal landscapes of both for-profit and non-profit sectors.
Peter currently serves as the Vice President and Senior Associate General Counsel for Privacy, Technology, Facilities, and Operations at the National Geographic Society. Before joining the National Geographic Society, Peter built a strong foundation in privacy and technology law with a variety of very interesting experiences that we are excited to share more about with you today.
With his background in privacy compliance, technology operations, and data security, Peter brings invaluable insights into the challenges and opportunities of building privacy programs. We're really thrilled to have him join us for what promises to be a thought-provoking conversation on the intersection of privacy and technology. Welcome, Peter.
Thank you, Donnie. Thank you, Kelly, for having me on. I'm really excited to be here today.
Yeah, we're really excited to have you. Peter, you've had a really impressive career, both in law firm context and also in like an in-house context. What drew you to privacy law?
It was pure dumb luck. So I started off my career as a financial services and financial disputes litigator, really, mostly civil litigation and some government investigations. And at one point, a little over 10 years ago, banking regulators started getting a lot more pointed with their investigations about bank databases. Some of it was about like bank safety and security and just having systems that were reliable. But nonetheless, I happened to work on one of these investigations and I liked it. And I had a little bit of technical background, nothing formal, but more than most lawyers have. And so I felt much more adept with some of this. I hope that my clients felt a little more comfortable with me as a result. It just worked well. Pretty shortly thereafter, you may remember around the same time, there were a number of these, so-called SWIFT hacks, not actually hacks of the SWIFT system, but hacks of banking systems. Then people send fraudulent SWIFT messages. I really dug into those cases and I really wanted to understand the law of those cases. Not really cybersecurity, not privacy law, not really technical law, but some of the law, like in the US, you've got the UCC dealing with, wholesale bank transfers. I dug into law and I wrote some blog posts. I produced my own little podcast-like video. And soon enough, a couple of clients came to me with actual data breaches. And from there, it was sort of off to the races. I did a couple of data breaches, and then I realized, like, hey, this is the way for me to go. It was never intentional, right? But it just, when you finally find that thing that wasn't even on your radar, but it just felt right, it felt better, I felt more comfortable with that. I kind of believed in it more, and it was a good choice.
That's amazing. So I heard data management in what you said, and I heard like security components in what you said. So how is that kind of fed into how you approach privacy now?
I still have probably spent more time on data breaches and data security than I have on privacy proper. It's probably like 55-45, right? It's not far off, but it does mean that I tend to have a more technical approach to a lot of what I do. I will ask my clients questions. How exactly does this API work? Is it spitting out a JSON, some other kind of data format? I'll delve into that nitty-gritty a little bit more than I think a lot of privacy lawyers will. By no means do I ever neglect important privacy concepts that are more sort of human-oriented when we talk about notice, when we talk about transparency. But I do really insist on understanding the technical details, because it's so often that you find that, let me be honest, I think a lot of privacy lawyers who don't delve into that often miss nuances that do have implications on things like transparency. So I really like getting hands-on with the details.
Peter, I'm quite interested in that because I think many of our listeners are aspiring privacy professionals, or they're very early in their careers, and it seems that privacy is becoming more and more technical. It's all about the tech these days. What kind of advice can you give to someone that's getting into privacy? Should they go and study a bit of software development on the side? Should they do some extra reading up? How much technical knowledge do you need, and where do you start if you need to get that background to help you do a better job?
Sure. Well, I don't think that you need anything super formal, right? Other than in high school taking an AP computer science course. I've never actually taken any sort of formal computer training, but I have engaged with it very significantly as an interest, and as a child of the 90s, as like a part-time after-school job type context. When I think back, I think there was really three things that I learned that were very helpful for me. I'm not saying that everybody needs to know this, but for me, I can't imagine being where I am now without having gotten these concepts. And the first was, very early on, I learned object-oriented programming with C++ and Java. Early languages are really popular in the 90s. And incidentally, like I sort of have a bee in my bonnet on this one. I think that everyone in the world should have to take this in school at some point, because it really changed the way I saw the world. When you're forced to really engage with classes and objects and functions and methods, inheritance and polymorphism, and some of these concepts, it changes the way that I saw everything in the world. I learned foreign languages differently. I approached social science classes differently. I certainly dealt with, math and logic and philosophy classes differently. It was really a transformative experience in my life in all respects. But for present purposes, I don't know how you can really advise a client unless you've at least messed around with those concepts. And how do you really understand an API? How do you really understand the distinctions between, a table-based normalized database and that sort of data, and hierarchical data and, an XML structure or like a JSON structure? Those sorts of problems just come up day to day so often in privacy and security. I can't imagine being able to advise my clients today without having had that background 25 years ago. The other one is, again, this child of the 90s, after school jobs, you're setting up like an Apache server on a Linux machine. You're a total amateur. You're doing this for a small business. Nobody knows what they're doing. It's really valuable. I can't imagine understanding modern permission systems, modern access controls without having had to deal and struggle and screw up, frankly, those 10-letter strings in Unix that tell you what the permissions are for a particular directory or file. That sort of messing it up and accidentally exposing a folder on your Apache server that you didn't mean to expose was really valuable, because now, even though the technology has long moved past that sort of thing and access control is much more sophisticated now, those basics and how easy it is to screw up those basics still made a big impression on me. And I still use that kind of understanding. I've regularly used that with clients well into my current career. And then the last one is, I did at some point have to really understand SQL and normalized databases, like 3NF structures. Again, nothing formal, nothing too sophisticated. We're talking about the first couple of weeks, an introductory college course. I probably wouldn't have even finished one of those introductory college courses. But understanding those basics is really critical. I have seen lawyers advise clients badly so many times because they say, oh, well, just like duplicate this column and like change the data a little bit way, without thinking through how that fundamentally affects data integrity of a system. And so understanding some of those core strategies for having well-structured data has been instrumental to making sure that I don't give maybe okay legal advice, but ultimately bad business advice for how my clients deal with their data.
We talk about this all the time. It's the difference between writing a beautiful legal memo that explains the law, but if you can't get into the weeds with that legal memo in any practical way, or you aren't cognizant of the practical challenges of implementing your advice, it's useless. It gets put in a drawer. Have you seen that in your practice that, either when you were in-house or at a law firm where you someone writes something that is perfectly, beautifully, legally sound and is utterly useless in practice?
I have seen that. I'm not sure I can really articulate the details with getting into confidences that I can't break. I can tell you what my reaction to some of them. I've seen advice that was unfortunately taken and led people to implement perhaps legally sound bad data structures that very quickly led to, for example, duplication of data about the same types of objects across two different tables that, surprise, surprise, become inconsistent very quickly, and you get data quality errors because it's no longer in 3NF format, right? So, yeah, I've seen this a lot.
It's interesting that you share those sort of conflict situations where sometimes you just have to put your foot down and raise the red flags. Sometimes even, I think in the life of a privacy lawyer or a privacy professional, that happens quite often, where you encounter some new proposed activity and there are major issues with it. How do you handle those in practice? Because often you're between the devil and the deep blue sea. How do you handle that conflict? How do you get the message across personally? How do you digest it afterwards?
In those cases I just mentioned, I was actually putting my foot down with other lawyers who were giving bad advice. But sometimes you do have to give bad news to a client, right? And there's a couple of things that I do. It's really important for the most part to stay, I would say, ruthlessly and rigorously analytical and logical and dispassionate. So what I'll often do is, I start by methodically identifying what are the potentially applicable laws. I'll go through each and I'll identify what is the element of every legal test that might apply. I'll consider, is there a way of flipping that element? Is there a way of changing what we're doing so that that element is or isn't triggered, and therefore the test comes out differently in a way that's more favorable? And I'll sort of rigorously do that. And that is, in some ways, you're being creative because you're trying to think of options for your client, but you're doing so actually in like a very methodical way. And you necessarily tend to be pretty comprehensive. Once I've come up with those options, I try to be very methodical about, for each one, what is the risk? And along really three dimensions. People always talk about probability and magnitude, and I would add probability, magnitude, and nature of the risk. Is it pure liability risk? Is it litigation risk? Is it reputational risk? And that really helps frame things for internal clients. And once I've laid all this out for a client, first of all, they're probably bored, or they're probably frustrated, but they're frustrated at that point with the situation. I've rarely had a situation where they look at that and they're frustrated at the lawyer. And that's really important because you need to maintain good working relationships over time. So they might be frustrated with the options and that they all come with risks, but they typically understand them. And it's typically for them to choose between the options and these different risks at that point. Now, I talked about being rigorously analytical and sort of ruthlessly dispassionate, but there is an emotional element, which is a lot of times people view privacy differently. We're living in a world that's changing quickly, and not everybody thinks the same way. So you still get some people internally who are kind of privacy skeptics. And that is a valid point of view. They are entitled to that viewpoint, and those are sincerely held viewpoints. As a lawyer, I need to accept that those are sincerely held and not be dismissive of them. At the same time, I need to help those clients understand that other people do feel strongly about privacy. One tactic that I use is I point to kind of two things that happened to me early in my career. By the way, I'm talking about when I was still like a financial services litigator. But once I had some clients, or I guess they weren't clients, but I had to deal with an elderly couple. It turns out that a lot of their family were lost in the Holocaust. And this couple understood, I don't know whether this is true or not, but they understood that the Nazis used bank records to track down a lot of their family members. And so they had a certain view about privacy. They valued it in a way that somebody who's always lived like a very comfortable life in America might not appreciate. Now, like I said, it's not like I verified that any of this is true or I evaluated whether they came to the right viewpoint or not. What was important was I learned to accept that that viewpoint is a sincerely held viewpoint and that people feel really strongly about it. I was also doing a pro bono case that involved a victim of domestic violence. That person had to keep her and her child's whereabouts secret from her abusive ex-partner, right? And this was actually part of the court settlements. When I think about these things, it helped me appreciate the sincerity and the strength of some people's views on privacy. And when I relate these to clients, I find that they often get it. They're like, okay, yes, I have my view. I'm not going to change my view, but I understand that other people have other views. And then you always have to add on, some of those other people who hold those other views are your customers or are your counterparties or other constituents. So this emotional piece is really important for helping get a skeptical client on board with the fact that their viewpoint, their normative viewpoint might not be the end all be all of the question at hand, right? Like they need to think about it in the shoes of somebody else.
I'm struck. You've said several things now, all of which I think are fantastically spot on in our experience too. And I'm just struck by how much of what you're describing is the lawyer's role as translator. You're translating the law, you're translating the perspectives, you're translating the technology. That's tough, though. I think many of our listeners are probably thinking like, gosh, this is a lot harder than I thought. I just went to law school so I could write a memo. Do you have any advice in light of that?
That's funny. I've thought about that sometimes. So when I was a litigator, I thought that I could write a brief. Obviously, nobody thinks that they're bad at writing a brief. So maybe I'm deluded, but I thought I could write a brief. I thought that I was good at the legal analysis section. I thought that I was, good at a conclusion or a statement of the case. But the one area where I always loved writing, and I felt like I was good at it, was the statement of the facts, because that is where you're often translating complex technical concepts, whatever, it might be a banking concept, it might be a technology concept. And again, I keep on going back to my experiences in high school where I would have to explain to a lay local business owner how this website works. And I would have to struggle and explain it, and they'd be like, I don't understand this. And I'd have to try to find some other way of explaining it. And they'd say, I don't understand. I'd try yet another way. And over time, that was one thing that I felt that I got pretty good at, was how do you translate it? So, maybe I'll go back to your earlier question. What training do you have to have? Maybe a technical writing class.
Yeah, that is good advice.
Yeah. Read a lot of user manuals or read some books on object-oriented programming, actually like a very difficult concept to get when you're first experiencing it. Maybe read how some of those books explain it to you. Those books use tactics like analogies a lot, which is something that I think are often disfavored in legal writing, but are actually really useful in technical writing and helps people understand things. I use analogies all the time. I've had that discussion with a lot of lawyers who very consciously disfavor them. So maybe go and go to your local bookshelf, buy a physical book about programming in Java or something for beginners, and then work your way through it. Then you can see how they explain concepts, if it's a good book, really, really clearly.
That's really practical life advice there. Some more practical advice I'd like to delve into, sort of foundational issues. Your in-house role, managing and looking after data privacy, building a privacy program, or going into an organization that has or doesn't have one. But what are the sort of critical first steps that you normally focus on, and what snags have you seen sort of along the way?
Sure. Well, and I'm speaking here for a variety of clients that I've dealt with over the years. Obviously, no one in particular, but focusing on that foundational why question has to be central. And actually, that's not something that you as an outside lawyer can necessarily bring to a client. You can bring some ideas. You kind of have to force that client to answer it for themselves. And sometimes you focus on the negative component. What is the risk? And understand that organization's risk tolerance. Are they risk loving? Are they risk averse? What kinds of risks? I talked about earlier, liability versus litigation versus reputational risk. What exactly is their risk profile? Helping them understand how these risks are actually playing out in the marketplace, how regulators and class action plaintiffs are making these risks really real for people. That is important. Now, that's the negative component, and that only goes so far. I think there has to be a really positive component as well. And that's where people talk about things like fostering the trust of their customers, or in the case of nonprofits, other sorts of constituents. So that one is something that you really have a hard time as outside counsel bringing in. That is something where, unless somebody's really been in an organization for some time and really understood what is motivating and driving it and how those constituent relationships matter, and then done some investigation into those constituents, is there some evidence of how those constituents feel about privacy and what their expectations might be? Unless you've spent some time delving into contracts, particularly your insurer contracts, to understand what their expectations are, it's really hard as outside counsel to suss that stuff out. But that is the long, hard, ultimately more successful way of helping a client understand that it is in their interests to meet privacy expectations, whether they're legal or more customer imposed or counterparty imposed. So that's the why, okay? And that takes a long time to answer, and you really need to sort of bring your client around to it slowly but surely so that they internalize it. Not just write it on a piece of paper once, but so that they really internalize it. After that, there's the how. That's also hard. And again, I think that one actually might even be harder for outside counsel to advise on, because I really don't believe that there's a one-size-fits-all privacy program. I've seen different governance structures work or fail at different types of organizations. The best advice I can give is make sure that your compliance and governance approach mirrors your governance and compliance approach for the organization generally. Is it a very centralized organization, decentralized, very hierarchical? Is it a matrix organization? You're going to need to find some way of mirroring that. You also need to really know the organization, because you're going to need help. You're going to need help from people who have maybe not legal or privacy experience, but who have some of these foundational technical skills that we were talking about earlier. And you're going to need to find those little pockets of skills throughout your organization. You're going to find a lot of people like this. A lot of people went to school for computer science or have some background in this, even if they're doing something totally different now, even if they're doing HR, or even if they're doing sales or something like that. And you need to find those people with those pockets of knowledge, because those are the people who are really going to help you discover what's going on and then really help you impose some sort of order on that.
That's fantastic. I do feel like we talk a lot about stakeholders as a word, but I think describing it as you've done, it's almost you're finding allies in certain ways. You not only are trying to convince the whole enterprise, the leaders of the enterprise, but you also need to find the people who can help you understand the context.
There's still tactics that outside counsel can use. And I think that my experience with VeriSafe is a good example, because as a consultant for this project and then DPO, you've been really great about slowly but surely learning our business. And I say slowly but surely, not pejoratively, but admirably, because that's the only way to do it.
So as an outside provider, whether it's a law firm or it's a consulting firm or it's some other kind of outside provider, you're up against that. You know that the how and the why both take a lot of time and a lot of conversations that you may not be able to have by virtue of the fact that it's too expensive for you to have them, or a variety of other things, right? So how do outside counsels most effectively, or outside providers most effectively, help with that?
I do think that long-term relationships are really important. I've certainly been in situations in litigation, this often happens, where a new case comes in and you always put it out to sort of bid with a number of firms. Whereas in this area, having one firm, or actually I believe in having always sort of two firms that you, as in-house counsel, that you keep around and bring in repeatedly, and you just have conversations about what's going on, even if it's not a billable hour, is really important. Now, that's of course what you can do as inside counsel. Outside counsel, I think, is just the flip side of that. Keep in touch with your clients, ask them how they're doing. Not everything has to be a sales pitch. I think if you just have a conversation with them, once every month, once every 2 months, ask what's going on, how things are going. No intention necessarily of building business. I think that client is, if they're smart, more likely to come back to you because you will have gotten a better sense for the internal dynamics of this organization and be able to do all of these hard things that I described where, really understanding the internal dynamics is critical.
Yeah, absolutely.
Going back to technology, because I think it's quite a theme of this session today. As external counsel or in-house counsel, in these days where AI is the buzzword, but just generally, what's your experience been with using technology, maybe AI or other software, to make your privacy program more efficient, to run it better, or sort of any tools that you can suggest? You don't have to mention names, but kinds of tools that people out there can take a look at instead of just using a spreadsheet.
There's lots of different technologies for privacy. I think the one that is probably most susceptible of being automated well is online privacy management tools. And these are the tools that are basically running what used to be called your cookie banner. Really, it's a privacy banner that are helping users control their choices about online privacy. At this point, I think there are a lot of good tools out on the market. It is sometimes maddeningly difficult to select the one that is right for you. And that's because they do have some differences. Those differences are not apparent on the surface. They are only apparent once you've dug into them. And not all of these providers have good sales teams that give you sandbox or testing environments when you're selecting them. For people in the technology world who talk a lot about, say, an agile versus a waterfall methodology.
Yeah.
Or paradigm for your work. Almost everybody agrees, I think, that agile is better, where you define some requirements up front, you implement, you realize that you missed some requirements or you misunderstood some requirements, and so you iterate and you keep on developing your requirements over time, as opposed to a waterfall methodology where you define all your requirements up front and then you implement and then you test and then usually you figure out that you got some things wrong. Well, unfortunately, when it comes to software procurement of off-the-shelf tools, the procurement process itself is necessarily waterfall, right? Like it's not going to be iterative. It's a one-time thing. A lot of these companies require 2-3 year terms. So you kind of have to figure this stuff out up front. And that just, I haven't figured out a good way around it. It's a difficult challenge. Definitely press those sales teams to see if you can get a sandbox environment that you actually implement on, like the testing or staging or development environments at your organization. That can be really helpful. And it's enlightening because you delve into it and you realize, oh, this tool might have features to solve a problem that wasn't even on my radar yet. And that is that amazing process of sometimes the solution comes before the problem, or sometimes you develop the requirements as you go. That would be sort of my best recommendation for privacy management tools. For things like records of processing activities, some of these platforms do have tools for those. I'm not in love with them because they're all exceptionally one size fits all. Frankly, a lot of them violate good data practice, right? They're like very focused on just here's something that we're doing with information. Whereas to my mind, what you really need is you'd need a database of activities. What are things you're doing with information? And then what are sets of data that you have? And then what are systems that house those sets? And then, what are entities that you're dealing with, whether as processors or joint controllers or independent controllers or something else? And when you've got a well-structured database, these things are all relating to each other, and you can generate sophisticated queries to get at the answers to certain questions. I just haven't seen anything really good like that in an off-the-shelf product. That said, there's some very good low-code or no-code tools out there, sort of like databases that allow rapid development where you can build these sorts of things. And that is nice because then you can iterate over time. And I certainly do with the systems that I've worked with, where you realize, oh, this is hard for users to deal with. Let's fix this. And you can fix it in the next sprint, in 2 weeks or something. It doesn't require a year-long procurement process.
You sort of alluded to, fixing things in the next sprint. Do you have developers on your privacy team?
We have an architect on our privacy team, not a developer. Cool. But we do have an architect, and that has been immensely helpful.
Yeah.
And my head would have exploded without that person because, I've said this many times, I have a little bit of technical background. It is very old and it's very informal, and having somebody who really understands the details of it is great. And I can serve as a translator between that person and the business.
I think that's fantastic. I think that's something, obviously we work on a lot of privacy compliance projects with a lot of different companies, different sizes, different industries, different budgets. And one of the foundational questions is always, okay, who's your internal privacy team? Who's working with us? And I think that speaking to the translation question and a whole bunch of other things, but having someone who's very technical is always absolutely critical. And sometimes that's missed. Sometimes it's a compliance problem or it's a legal problem. It's not an IT problem, but in fact, or it's an IT problem. It's not a product problem. And actually it's a product problem, or you need product buy-in.
You're hitting on something that's even more generally important, which is that the privacy program cannot be a strictly legal one, right? And it needs to involve, obviously, probably one or more people from the technical standpoint, but you also need your communications experts and you need your training experts to sort of help make sure that you are dealing with the human side of privacy as well, which I always say, like, part of me is very technical, but that human side is absolutely essential and can't be neglected. Lawyers like to think of themselves as really great communicators, and often they are. Lawyers do a lot of CLEs and they feel like they can sort of do training without any kind of input or help. But having people who really understand those areas, first of all, takes some of the pressure off of you. But I do think that it produces a better result in the end. I think that there's an important deference to those areas of expertise.
We do have a question here about training and the role that it should play in building a privacy program or maintaining a privacy program or what have you. Any thoughts on that? How to make an effective privacy training, how often you should do it, who should be involved, any of those kind of things to make it effective?
So I haven't seen a lot of off-the-shelf training that I think is great. Sometimes the content is good, but it is insufficient because it isn't really tied. It doesn't necessarily resonate with your client's business. And so I would never use it alone, but I might use it in combination with some sort of homegrown material that makes it real for people. Even so, I find that some of the off-the-shelf stuff tends to be kind of generic. The other thing is that, and this really depends on how you set up your internal governance and compliance structures, but a lot of times the privacy trainings try to skim over the entirety of privacy principles. Let's just say we're using the GDPR Statement of Privacy Principles, or FIPS, or something like that. They'll try to skim over everything. They'll give a little bit of attention to everything. Sometimes they'll try to give a lot of attention to everything. I think that tends not to get internalized very well by people. So I really believe in separating out what does your privacy team, whether it's privacy governance or privacy compliance or other teams, need to know versus what does everybody else need to know. I don't think it ever helps to teach people the nuances of data subject request practice, or, it's a 45-day period in this jurisdiction versus a 30-day in this other. Nobody's ever going to retain that or internalize it or probably ever use it. But what you do need everyone to understand is when and how to ask for help. Number one thing, when and how to ask for help. And in turn, what that usually means is people need to have a really crystal clear conceptual understanding of what personal information or personal data is, because it's so easily misunderstood by so many different people. And you've got these older terms like PII that float around, and people have so many different understandings, so many different inconsistent and wrong understandings of what PII is. And it's not even that useful legally as a term anymore. Most modern laws are using personal information or personal data. Helping people understand those, helping them understand how those relate to pseudonymized or de-identified or anonymized or aggregate information. helping people understand some of the basic foundational technologies that we use today, and how those use personal information, or how they might use persistent online identifiers and how that data flows. Some of those things are going to be more beneficial to you, because then when you teach people about what is personal information, what are some common but hidden ways that it might be used, that's when they're going to know when to ask for help. And then how to ask for help, it varies from company to company. It's obviously how you've structured your program, but that needs to be crystal clear to people. When you separate out that, what does our privacy compliance function need to know versus what does everybody need to know, I think it lets you build a training that covers less, but in much more depth. And I think that's also more likely to be retained and internalized. It's frankly more interesting to watch, right? Like if you try to cover 7 privacy principles in an hour, I just think that people are going to tune out after about principle 3.
I have a totally different question. The US privacy laws are coming out at a pace at the moment. And I think many lawyers and in-house counsel out there are responsible for global privacy programs. And initially the focus was all on Europe and the GDPR. But now suddenly they have to focus on more than just that. Any practical tips, any thoughts on how to approach your privacy program, but also make sure that you comply with all these laws to the extent that they apply?
I don't necessarily disagree with some of the conventional wisdom, which is that these privacy laws tend to be based on the privacy principles that have been articulated in different ways, but are largely constant and have been for over 40 years. So if you do comply with GDPR and say, if you're a commercial enterprise CCPA, you're going to get yourself, 80, 90% of the way there. That's just a number, but I feel like that's about right. The question is what to do with the next 10 or 20%. You can't neglect the fact that a lot of these laws are different. They do have their nuances, and sometimes jurisdictions are very proud of their nuances, and therefore you ignore them at your peril. So for that, I think there's 2 things. One is, both of them are about outsourcing, right? You're going to have to outsource. Trying to do this all in-house by yourself is going to be impossible. So having a really good international law firm is important. I'm always caveating. That's not to say that national law firms are unimportant. I still have a national law firm that I think is really, really important for what we do. But having an international law firm who's able to cover a substantial number of jurisdictions worldwide and then has their own networks to sort of get advice in the other places is really critical. Those law firms are typically doing this on a repeat basis. They get efficiencies from this. They're just going to do typically a good job. And it's in their interest to bring developments to your attention. So the market really works in at least that respect. The other outsourcing strategy is, I do think a lot of the modern online privacy management tools are pretty good about making sure that they're keeping up with international requirements, and they are modifying their online behaviors based on whatever laws apply in a particular jurisdiction. I've even seen this increasingly in things like, CRM, customer relationship management platforms. I've seen this in some customer consumer data platforms where there's a lot of optionality down to the jurisdiction level. I suspect that this is just market forces working in a sensible way. I suspect that these providers realize it's in their interest to provide this to people. My hope, and frankly, I think it probably will, we probably will see this trend continue and accelerate. So I'm keeping my fingers crossed. I'm cautiously optimistic.
I think you're right to flag. I really smiled when you said there are quirks, there are nuances, and some of the particular regulators or drafters or what have you of the legislation, they care about, they're proud of those small differences. I was thinking of the double opt-in in Austria and Germany, for example. And I think that's important to keep in mind. It might seem like a pedantic thing, but it's important to keep in mind.
No, absolutely. I try to remain rigorously analytical, but the emotional part can't be neglected.
Yes. Regulators have feelings too, so.
Yes.
Peter, thank you so much. This has been really interesting. I feel like this has been wonderful in all of the very practical takeaways. It's clear you've done this successfully and thoughtfully. And so now I'm going to ask you a hard question, which is, can you give us 3 actionable steps for any organization, but maybe perhaps those with tighter budgets or more practical constraints to strengthen their privacy program?
Number one is I think finding allies. I think that was actually the word that you used earlier, and I think it's a really good one. Finding allies throughout your business, making them aware of some of what's happening in the world when it comes to privacy is going to be really important, because when you find those allies, they're a force multiplier and they will do a lot of the work for you. Hopefully, it can also end up being both a grassroots effort where they are pushing upwards, and then also you're speaking to leadership and pushing downwards. And hopefully you get both approaches so that you can move the organization in a good direction. The next one is it is impossible to do anything with a privacy program without knowing what your organization does with information. Many people have made this point. It all starts with a data mapping exercise or something akin to that. As I mentioned earlier, I think it has to be more complex than mapping your data. I think it has to be a relationship of things. Unfortunately, that one is rarely cheap. That one, I don't know of any way of shortcutting that one. So budget constraints or not, you're going to have to do that one. And then I think the last one is finding your external allies as well. And by that, I mean your advisors, or maybe your outside privacy management technology partners. You can't do it alone if you're in-house. And I think that having those people outside who get to know you is really critical. So it's, some in-house counsel feel like it's the responsibility of outside counsel to develop the relationship, because, they're the ones with BD budgets and things like that. But I think as in-house counsel, you also have to develop that relationship. It is in your interest to have your outside counsel really know you.
Such good thoughts.
I want to play the clip of you saying how important data mapping is on every single call I have going forward. It's expensive, but it's important. I think that's the takeaway.
Well, and at last year's IAPP, if you went to the state AG panel roundtable, I don't remember what they called it. Almost every one of them said that. It's so funny because, in Europe, it is a formal requirement by way of the ROPAs. It's not in the US. And yet the most important, it's not explicitly stated, and yet it's the most important thing that comes out of all of these laws.
Can't manage what you can't measure.
That's it for today's episode of Privacy in Practice, brought to you by VeraSafe.
If you enjoyed today's conversation, be sure to subscribe so you don't miss out on future episodes. And we'd love to hear from you. Send us an email to podcast@verasafe.com.
And to learn more about VeraSafe's data protection and privacy services, you can visit us at verasafe.com.